so thank you all for being here. If everybody would come in and take their seats, I'm going to try to keep us on schedule going forward. What? Okay. Okay, Agile just reminded me that the live stream is up and going. So welcome to all of you who are out there in cyberspace joining us remotely. And everybody who's in the room, please feel free to share the live stream with friends who aren't here so that we can broaden our reach. So this panel is on the role of international law in US domestic advocacy and law reform. And when we planned this conference about implementing the Declaration on the Rights of the Indigenous Peoples in the US, we thought we better try really hard to get serious about it and to talk about the status of the Declaration, the more general questions, conceptual and technical, about using international law in domestic legal reform, and then also try to provide an example, a case study. Along those lines, we have an all-star panel, and I'm going to introduce them briefly, in part because these are some of my closest colleagues and close friends in many ways, brothers in the struggle, and also because we now have the bios on the website, and we want to really get to the heart of this. So as you know, James Naya is the Dean of our law school. He's a tremendous scholar, in many ways has made the intellectual case for Indigenous peoples in international law. He was formerly the UN Special Rapporteur on the Rights of Indigenous Peoples and is truly a scholarly and intellectual and personal leader and mentor for so many of us in the field. Steve Moore is an attorney at the Native American Rights Fund. He has litigated many of the most important cases in federal Indian law, and especially in the realms of religious freedoms, which is what we will do our case study on after Dean Anaya speaks about the technical and conceptual case. Steve is an attorney who I've admired for so many years, and when it gets to the how is this really going to work in litigation or in administrative practice or in legislation, we have Steve as the really serious practicing attorney to help us answer some of those questions. He's often our reality check. Greg Johnson joins us from the Department of Religious Studies at the University of Colorado. He's been a leader in the Center for Native American and Indigenous Studies, and he brings the perspective to the religious study case study from religion. And it's so important, I think, in our field to realize that these aren't purely legal questions. And especially when it comes to things like spirituality, we really need an understanding, interdisciplinary understanding, as well as, of course, informed by experience on the ground. And Greg has been very deeply involved in supporting advocacy, especially in Hawaii, around sacred sites and repatriation, and he brings that experience to bear on this panel. The four of us often work together on actual cases, on amicus briefs and otherwise, and we'll kind of be toggling back and forth a little bit after Dean Anaya gives us the opening address. So thank you all.
Thank you, Kristen, and I really do feel like I'm among friends here on this panel. Steve was just whispering in my ear, asking me if I remembered the amicus brief that we worked on years ago in a religious freedom case and what the specifics of that case were, and neither one of us could exactly remember anyway, it's been that long. So it falls upon me to talk about the nuts and bolts and the technical aspects of the relationship between international law, the Declaration on the Rights of Indigenous Peoples, and decision-making within the U.S. domestic arena, including the United States courts. First of all, what do we mean when we talk about international law? So these are the classic sources of international law. Those of you who know anything about international law know about these. The one thing you'll note about them is they're very state-centric, and so the recitation of these sources reminds us that we really are talking, when we talk about international law, state-centered system, and there are limitations, hence, associated with the system. First of all, treaties or conventions, which are the formal agreements between two or more states. In international law, at one point, treaties with Indian tribes were considered national treaties. Now, there's a big debate about that, and I've argued that treaties with Indian tribes still are treaties for the purposes of international law, but that's very contested. Secondly, international custom or what we call customary international law. And this is the law that arises from the broad practice or consensus among international actors about obligatory rules. And those international actors are typically understood to be states or governments or also international institutions. Increasingly, we understand those international actors to include other powerful actors within the international arena, and I would argue including indigenous peoples because of their place within the international system. The general principles of law, these are those general principles that are common to different legal systems in the world. And then I like this one, the secondary source. This is the judicial opinions and authoritative scholarship interpreting these above. So that means that scholars who write about these things are at least a secondary source of international law. Okay, so what is the status then of the Declaration on the Rights of Indigenous Peoples in connection with these sources? Now, it is not a treaty. It is not a formal agreement between states that's gone through the procedures of treaty making. And certainly it was not intended by the governments that have voted in favor of it to have that status of a treaty. It is a resolution of the General Assembly under the General Assembly's authority to make recommendations. So technically, it's a recommendation. And governments will often remind us of that. Oh, it's not technically binding, it's just a recommendation of the General Assembly. But I think it's fair to say, and I have argued and others have argued, that the Declaration does represent international legal obligations inasmuch as it can be seen as interpretive of existing obligations under treaties that are binding on states. Now, what do I mean by that? Now, the U.S. and other countries, obviously, are parties to a number of bilateral or multilateral treaties, including human rights treaties. The U.S. in particular is a party to the International Covenant on Civil and Political Rights, which includes a number of provisions of general human rights, including equality, personal integrity, and cultural integrity. The U.S. is also a party to the International Convention on the Elimination of All Forms of Racial Discrimination, which, as the name suggests, advances of the fundamental human rights norm of equality and non-discrimination. Now, both these instruments have been interpreted, and many times in reference to the Declaration, as relating to indigenous peoples' rights. So the Declaration can be seen as interpretive of these human rights norms that are found in these international treaties, and hence, at that sense, it can be seen as having legal meaning, as being interpretive of human rights norms already found in human rights treaties that are of an obligatory character. Secondly, the Declaration, very arguably, and I have argued, reflects customary international law in a number of its provisions. Now, like I said, I've argued this and have written about this, but don't take my word for it. Others have, and perhaps most importantly, an authoritative committee of the International Law Association, of which Daley Sambo was a part, I believe, right? And which included not just indigenous advocates, but some very conservative international legal scholars from around the world, engaged in a multi-year study in which they examined the meaning and implications of the Declaration in international law, and concluded that in several of its provisions, the Declaration reflects customary international law by virtue of reflecting a certain universal practice among international actors and consensus within the international community. And this study, which was published in 2012 and which was approved by the entire General Assembly of the International Law Association at its meeting in Sofia, Bulgaria, concluded that among these norms of customary international law that can be seen reflected in the Declaration include the duty to consult, which, as we know in the Declaration, is framed as a duty to consult in relation to obtaining free, prior, and informed consent. Also, the right of indigenous peoples to enjoy their cultures, or the basic norm of cultural integrity, including the right to culture in relation to sacred places, and the rights to traditional lands, at least those lands that are currently occupied, and there is a need under customary international law, as stated by the International Law Association and as reflected in the Declaration, for states to provide procedures for claims to lands that have been taken illegitimately. These are some of the custom international law norms that the International Law Association Committee identified as being reflected into the Declaration. So we can see the Declaration does have legal implications. And interestingly, this argument about the Declaration having legal implication hasn't really been joined. In discourse, when I was UN Rapporteur, I would often talk with states about what the Declaration implied with them, implicated for them, and their standard response was, oh, it's not legally binding, and it was very hard to get beyond that. And we haven't seen courts, at least in this country, really engage with the Declaration and examining these arguments or assessments of the legal character of the Declaration. But I think we can see that there are sound arguments and foundations for seeing the Declaration as having a legal character. Okay, so what is the relationship between the Declaration on the Rights of Indigenous Peoples and domestic decision-making in the United States? Now, in general, the U.S., as other countries, has a legal obligation to conform its laws, policies, and decisions to applicable international law. That's the basic doctrine of state responsibility. And that's just a corollary of the obligations that appear in the sources of international law. And so that implies that with regard to Indigenous peoples' human rights, that the U.S. should take those actions necessary within its governance and administrative structure and legal standards and statutory law and otherwise to conform to human rights standards. And so to the extent the Declaration is interpretive of treaty norms or represents customary international law, the U.S. is obligated to follow those standards within its internal structure. Now, that's very contested, that statement. Now, I hope I've sketched the argument for that assertion. But at the very least, and this is hard for governments to contest, the Declaration is a policy statement. And for the United States, it's a policy statement that it has joined in regarding the rights of Indigenous peoples. And we see this specifically in the statement by the United States, particularly a paper by the U.S. State Department upon the U.S. declaring its support for the Declaration on the Rights of Indigenous Peoples in 2010. In that paper, it is explicitly stated that the Declaration and the standards and objectives of the Declaration are part of U.S. policy. Now, I know that, and a few people in the room know that, but it's not generally known, as many of these things having to do with Indigenous people's rights are. But so it shouldn't be really a matter of contestation that the Declaration, whatever its legal status, is part of the policy of the United States. It's declared formally through a statement by President Obama and in a statement by the State Department, support for the Declaration, and that the Declaration is part of U.S. policy. Now, you might ask, well, what about the Trump administration? Well, the Trump administration has not retreated from that position. And the way federal policy works, as you know, at least in a formal sense, it continues until retracted by a subsequent act. And so it's policy of the U.S. And it's not just policy in the sense of something that's convenient, something that's arrived at by some transactional means. It's a policy statement that is particularly weighty because, as we've seen, as we've heard, it is rooted in fundamental human rights principles. And so it relates to the U.S.'s supposed commitment, and I would say genuine commitment in many respects, to promote and respect human rights. It relates to those fundamental moral principles that we see attached to human rights. So it's not, my point is, just any policy commitment. So the policy prescriptions that are represented in the Declaration and legal obligations, to the extent they exist in the Declaration, they run primarily to the political and administrative branches of government. We heard Walter talk about how international human rights law, it has as its main enforcement or implementation mechanisms the domestic aspects of a governance structure. And in our case, those are Congress, the executive, and the courts. So Congress, as we know, has the power to enact reforms in existing legislation and federal programming concerning Native peoples, and to bring those programs and legislation in conformity with the Declaration. So, for example, it has the power to reform the Antiquities Act or other legislation to provide greater protection for sacred sites. And this implies that a whole legislative agenda can be developed to advance reforms, legislative reforms, in favor of the indigenous peoples in conformity with the standards of the Declaration. Likewise, the executive branch and its various agencies can advance implementation of the Declaration in accordance with their discretionary powers granted by the Constitution or statutory directives. These executive agencies do have discretionary powers, as we know, and within those discretionary powers, they can advance implementation of the Declaration. So, for example, the U.S. Forest Service could come into greater conformity with the Declaration by conforming its consultation procedures with the mandates of the Declaration. Okay, now what about the relationship with judicial decision-making? Now, there are a number of ways that international law can enter into judicial decision-making. Many of them are quite limited, though, and simply mostly in the realm of theoretical possibilities. But I want to talk about two specific ways that I think are pretty safe, pretty clear ways in which international human rights norms regarding the Declaration of the Rights of Indigenous Peoples, or in connection with that, can enter into domestic decision-making. Walter mentioned federal common law. Now, there is a big debate among scholars and within the courts about the extent to which federal common law exists, and ever since the Erie Railroad versus Thompson case in particular. But we know there's federal common law, and where it lives in the courts, as we see, is with regard to Native peoples, and that's the body of law we call federal Indian law that goes back to the so-called Marshall Trilogy. And what we see is that, and also what Walter referred to, was that at its inception, this body of federal common law incorporated international standards, as federal common law can do. As a theoretical matter, and really not just theoretical as regards to indigenous peoples, international law, and particularly custom international law, is part of federal common law. And that, in fact, was the case at the beginning, at the origins of what we call federal common law. And so it is completely within the realm of possibility that federal common law can now be reformed to conform to the federal common law that would conform to the Declaration on the Rights of Indigenous Peoples. And so courts should be called upon at every possible opportunity. Now, it's not going to happen right overnight, but I think Matthew Fletcher, gave us sort of the spirit of what we should be thinking about when we think about those possibilities, how federal courts can eventually see their way toward incorporating indigenous people's rights as articulated in modern instruments, particularly the Declaration, into federal common law. And we've seen this happen in other jurisdictions to some extent. The Australian High Court in 1992 in the Mabo decision reformed basic precepts of law, did away with the concept of terra nullius in order to conform the common law of that country to modern concepts of equality. So, apart from this common law argument, international human rights norms can be referred to just as any other secondary sources can be referred to as interpretive devices for existing norms regarding Native peoples. And so you think of any standard regarding Native peoples that we see in domestic law, any statute, at least arguably, those statutes can be interpreted in light of the Declaration of the Rights of Indigenous Peoples. And there's precedent for that. Even in recent times, the Roper decision, Roper versus Simmons, we see the Supreme Court looking to international standards to confirm its decision doing away with the juvenile death penalty, declaring the juvenile death penalty or the death penalty for minors in violation of the 8th Amendment of the Constitution. So we see there an example of where the Constitution is interpreted in light of international standards. Similarly, we could see that happen with regard to constitutional or statutory or other norms having to do with Native peoples being interpreted in light of international standards. So finally, what all this suggests are a series of strategies that you see them there, and I'll just read them real quickly. First, developing a legislative agenda to advance implementation of the Declaration. And there are a number of possibilities that could be discussed about this. Secondly, use the Declaration as a tool in efforts to reform executive administrative decision-making. Thirdly, develop and deploy arguments as appropriate in federal courts to modernize Indian law. That is common law regarding Native peoples. And to purge it of its negative aspects that are based on 19th century international law. Walter Echo talked about those, the dark side of Indian law. We could see the common law of the federal common law regarding Native peoples being purged of those dark sides by incorporating, instead of those colonial era doctrines of the 18th and 19th century, instead of incorporating those, incorporating the customary international law norms or international law policies regarding Native peoples of today. And then finally, we can use the Declaration to interpret relevant constitutional and statutory norms and judicial doctrine, just as we see international norms in other areas being used to interpret constitutional and statutory law and judicial doctrine. Thank you very much.
Thank you, Jim. That was an incredible tour de force vis-a-vis the role of international law and domestic law reform. And what the three of us are going to do in our remaining time is, as I mentioned, advance a case study, taking the principles and the approach that Dean Anaya has outlined and suggesting a means of putting them into practice. And the subject matter that we've chosen to address is religious freedoms, as I've mentioned, largely because the three of us have devoted our careers to that, and because it's an area that is so extremely in need of legal reform, both in terms of the basic well-being of Indigenous peoples, but also fundamental norms of justice. It goes to the First Amendment and fundamental American values vis-a-vis the freedoms of our citizens. And I will just offer a few sort of contextual remarks and then turn it over to Steve, who will talk more robustly about federal law, and then to Greg, who will talk about some state examples in Hawaii, and then we'll bring it all back to the Declaration. And I did want to say this is the time when we're going to get serious about the Declaration. We passed out a booklet for everybody, and we're actually going to refer to specific articles and do some serious thinking together about it. So as many of you know, Indigenous peoples are in many ways inextricably tied to place. For many Indigenous communities, their identity comes from either an emergent story or a creation story or a migration that situates them in a particular homeland. And that homeland gives rise to values and norms that dictate and guide our lives on Earth, our relationships with one another, our relationships with the natural world. The Navajo delegate, I think, mentioned when he gave his prayer some of the aspects of that worldview. And of course, they're specific to each Indigenous people, but it is something that Indigenous peoples typically share. There are all sorts of examples around North America of these sacred places that go to identity, but not just identity, also to contemporary ceremony, to religious rituals, to prayers, to the ability to practice what in American law terms we would call religion. Many of those sites are deeply threatened because in the process of conquest and colonization, they have become owned by the United States and managed by the federal government, especially through land management agencies. And we all in our practices could give you dozens and dozens of examples, and a number of those have gone to the United States Supreme Court, of places where for the tribe to maintain its existence as a people, they need ongoing access to that place. And there's a tremendous amount of outpouring of literature by Native peoples who have said, when this place is destroyed, we, the Cherokee people, or we, the Navajo people, or we, the Hopi people, will cease to exist as a people. So this goes very deeply to the survival of Indigenous peoples, but those values are not at all remotely protected when our Supreme Court interprets the First Amendment. And when Jim was talking about the Declaration as an aspect of customary law or federal Indian law, or at least as an interpretive device, this is an instance where we feel like the Declaration, with its many provisions on spirituality, on religious freedoms, on sacred sites, on repatriation, on traditional knowledge, and so on, could help to reform the law in these areas. Oak Flat for the Apache people was sold by Congress to a multilateral mining company. This is a place where Apache people, and apologies if there's in the room who I'm misstating this, but engage in a coming of age ceremony for their women. This goes to their women's ability to become adults, to participate in their roles in the community. And there's so many other examples really throughout the United States. The events at Standing Rock brought a lot of those into contemporary attention. And I'm going to turn it over to Steve to describe in more detail the doctrinal and advocacy history that gets us to this moment where these are really quite acute issues.
Good morning, everyone, and I think my mic is active now, so I hope you can hear me. Yeah, Greg and I are going to take maybe 10 or 12 minutes each to talk about our respective portions of this presentation. We hope to have a little bit of time for question and answer at the end, or at least some dialogue between the four of us. So I'm first going to talk about this area as a practicing lawyer and my obligations to my client in trying to protect sacred places. The essence of this work is being able to make a record, an effective record, for a trial court and for appeal. And so I'm going to be talking in a minute about how important meaningful consultation is, and I think that's a place where UNDRIP could really help inform this work, is free, prior, and informed consent, and the principles of consultation in this area. Because I think so many times courts have gone astray in this area because of the lack of a meaningful record and a lack of understanding about sacred place and the role that place plays in society, in cosmology, in worldview. And so I've got a long PowerPoint here, but I really am probably going to blow through most of it like Matthew. I probably do better when I'm just pacing and not tied to something. The first slide here, though, does talk about why UNDRIP's application is relevant and important, and that's because of the history of the disrespect of Native cultures generally, and certainly religion, the antagonistic attitude of the United States as a matter of law and policy, outlawing dances, outlawing Sundance, the forced cutting of hair, the forced stripping of children of their language. All of this dismantles culture and dismantles religion and cosmology and worldview. The confining of Native people to reservations. Most of those reservations were not selected, so that the sacred places were set aside as part of the reservation. When you're cut off from those sacred places, you then become dependent upon the federal government for access to and use and protection of those places. We've talked about, and Jim mentioned, the Forest Service and these land management agencies and the frustrations of trying to work with them. And then we've got the judicial decisions, of course, that culminate from the advocacy below. The AIRFA, American Indian Religious Freedom Act in 1978, of course, Walter was involved in that, and John and Suzanne Harjo. Jim mentions policy, the word policy in relation to UNDRIP. AIRFA was a policy statement by the U.S. Congress, a joint resolution. protecting the exercise of religion and access to sacred places. And I think there was a lot of optimism and hope that ERFA could become something meaningful and proactive and affirmative for advocates and activists in this area. But I think the litigation that had preceded and followed ERFA showed that courts really didn't give it much shrift at all. Courts were limiting the claims of Native peoples at that time for some pretty curious reasons. No property right in a sacred place. That makes a mockery of the nature of the indigenous relationship to a place that could have gone on for 10,000 years before the arrival of Europeans. The substantial burden standard, which I really don't have time to talk about today, much at all. But anyway, courts were not the place to go for justice in this area in enforcing ERFA. One exception that Walter and I and Doug Anderson at NARF were involved in the late 70s and until 1987 involved Sacred Waterfall in northwest Montana, where we did prevail in beating a group of utilities for a FERC license. And so Kootenai Falls still flows freely today. We had, in addition to the religion claims in that case, we had a number of environmental issues. We had the state of Montana on our side. And so, you know, that's certainly a notable exception out there. But very important lessons from Kootenai Falls in terms of making a record. Then we move on to Ling, of course, and John Echohawk mentioned how the courts were going south on us in the late 80s and 90s, and I think that the Ling case involving the high country in Northern California, got a picture of it there. How can a court reach a decision that you can destroy a religion and not violate a tribe's First Amendment rights? I mean, that's the ludicrous result or outcome from the Ling case. The court also said that ERFA, as a final nail in its coffin, was just the sense of Congress, and it had no teeth. So there went the enforceability of ERFA if, as a substantive right of action. It always has had some procedural benefits, of course. And then Oregon versus Smith, involving the Native American Church. Really, the only lesson from relevant to today from the Smith case is that it prompted Congress to enact, in 1993, the Religious Freedom Restoration Act. And I think like ERFA, then RFRA, as we call it, gave tribal peoples, tribal advocates, some sense of optimism about some enforceability. But RFRA, as we found out, I think pretty quickly, the religious coalition that was able to push for the passage of and succeed in enacting RFRA wanted nothing to do with the Native American constituents out there, both the Native American Church, and we had to go get our own legislation in 1994 recognizing the right to possess and use and transport peyote as a matter of federal law. But they wanted nothing to do with this strange kind of aberrant group of claims to protect sacred place. Not only that, we were not part of that coalition in enacting RFRA, but then soon we saw that the litigation involving RFRA in the Snowbowl Case in the 1990s or 2000s, where the court basically then imported the Ling standard. And this case never went to the Supreme Court. It's the Ninth Circuit. But bringing the Ling standard in, what we see in the middle of this slide, the coercion standard, as it's called, importing that from Ling into and interpreting the Religious Freedom Restoration Act. So, you know, what we're left with today then is a set of laws and judicial decisions that are difficult to work with, that really don't provide much substance for tribal people in attempting to assert claims to protect sacred place. And I think advocates these days are trying to rely more on the National Historic Preservation Act, on NEPA and the like. That's not to say that RFRA claims aren't being brought, but I'm afraid that what could happen is that the Snowbowl case at some point will just become extended by the Supreme Court and become the law of the land. So now to the essence of why I wanted to talk with you today. And in terms of a record and how UNDRIP could help inform this whole area. This was a remarkable piece of scholarship in 1990 by Joe Singer, asking some fundamental questions about the nature of coercion in this area. What do you have to believe to think that there is no coercion involved in forcibly desecrating sacred lands? You'd have to believe that physical places are not central to religious practice. You'd have to believe that forcible removal of a person protesting desecration of a sacred place is not religious coercion. You'd have to believe that alteration by human beings of natural spaces is not an intrusion on religion. You'd have to believe that religion is not connected to a place and can be practiced anywhere. You'd have to believe that coercion arises only when the state requires forced avowals of belief or prohibits the practice of ritual. I don't think anyone has ever said it better than that, nor do I think it could be said any better than that. And another slide on why place is significant in Native religious practice and belief systems. Because substantially altering the physical integrity of a sacred place compromises its spiritual integrity, prevents practitioners from carrying out ceremonial practices, prevents the passing of ceremonial practices to the next generation, injures the integrity of a people, their religion, and their culture, and then the burden on religion is borne not just by the present generation, but also by future generations who will not have the opportunity to learn the rituals and in turn pass them on. So when I talked initially about the importance of making a record, all of these different fundamental aspects of religion and cosmology and belief system have to be dealt with, and you have to make a record of all of this. Now, Vine Deloria said it best, a willingness on the part of non-Indians and the courts to entertain different ideas about the nature of religion. These are different religions. They're fundamentally different from Christianity, for example. There are examples of meaningful accommodation, a few throughout time, Taos Blue Lake, and purchasing of sacred lands, closures of Forest Service lands for ceremonial purposes, and then some nice group of conflict resolution settlements at Medicine Wheel, Devil's Tower, and Rainbow Bridge National Monument. Those were done, I would add, in the context, if you go back and look chronologically, those were done in the last three in the context of RFRA and before the Snowbowl decision. You know, I'd like to know how federal agencies are acting in this area post-Snowbowl when they're now told that, don't worry, you're not going to be put to the test of proving that the interests of the government here are compelling. So I'm going to close for now, and Greg, I think, is up next, and then we'll hopefully have a little bit of time for questions and discussion. Thank you very much.
Steve, awesome. Okay, it's good to see everybody here. It's really an honor to be here. Thank you, Kristen, for inviting me. It's also very humbling. I want to note two people in the audience who've helped me think a lot about the issues. I'll briefly mention Carla Fredericks has worked with me in Hawaii some recently and helped me think about what's going on there. And Michael McNally is writing a book about Indigenous religious freedoms that's going to retell the story in powerful ways. So, really what I want to do this morning in just a few minutes is give you two examples of the way UNDRIP is being spoken by people on the ground in Hawaii and to what effect. Okay? So it's really a question about Indigenous peoples asserting their auto-jurisdiction, their legal sense of self. That is, they recognize state, federal, and international authorities, but they also recognize fundamentally that they have the right to speak as legal beings in their own voice. And in doing so, they draw upon the UNDRIP in various kinds of ways. You may know that in Hawaii, there's quite a robust constitutional framework for protecting Native Hawaiian rights. And it's right there, I won't read it. But many contemporary Hawaiians look to this framework to say, you know, our lands, our practices, our subsistence rights ought to be defended. And sometimes they have been. But increasingly, there's a disconnect between these state-level mechanisms and the aspirations of living Hawaiian peoples to exercise their traditional and customary rights. To fill this vacuum, Hawaiians have self-educated about the UNDRIP and related things, and also their own history as subjects of the Hawaiian kingdom. That deserves to be said. And so I'm very interested in how it is they articulate their understandings of the UNDRIP with what's happening on the ground to them. So I'll talk briefly about what's happening on Mauna Kea. You may know that there's an ongoing land use dispute there. And by the way, stay tuned. The next round of protests seem to be just on the horizon. The state Supreme Court has approved permit for construction of the 30-meter telescope as of a few months ago. And the state's getting ready to implement new rules of administration on the mountain that criminalize protests, much in the way protest was criminalized at Standing Rock. And I think they've drastically underestimated the will of Hawaiians to stand their ground. The other case I'll talk about very briefly is an international repatriation. I happened to be on the Mauna during the major protests of the summer of 2015, and as a scholar of religion, I was blown away. The amount of ritual language, prayer, traditional oratory. This wasn't merely a political event. This was religion coming alive, being recast, reframed in a moment of intense need, and that's just how tradition usually works, right? We lose sight of that over time. We take as dogmatic certain statements, or we canonize certain texts, but they're almost all coming out of moments of intense political friction. So I'm preaching to the converted here to say we should recognize this too of contemporary Indigenous traditions, that these moments that might appear political to some are also deeply religious. One practitioner in the Mauna Kea case is William Freitas, and he conducts protocol near the summit of Mauna Kea at an ahu, a shrine that he and others built in the course of protest. This is at almost 14,000 feet. That's Maui in the background. So I got involved with him through the course of a contested case process and learned about his commitments, his practice on the Mauna, and watched him and helped him through the contested case process, and most of all felt, along with him, his deep disappointment in the state that he was not heard. That as the hearing officer said in the case, no new facts. This is after a year-long contested case process, no new facts, including introduction of the UNDRIP by many of the people in the room. There were 20-some interveners and petitioners, many of whom explicitly testified about their rights by means of the mechanisms of the UNDRIP, and none of that made the official record in terms of what the hearing officer deemed worth considering as a fact. And then the state Supreme Court went on to effectively certify that position. So at the end of the day, he was so hurt by this because he knew they would probably lose at the end of the day, but he expected to be heard. He expected for their rights to at least register in some way, their practices to be taken seriously, And I could see him and others just feeling further marginalized from the state and its mechanisms, but still holding out hope for the UNDRIP and related kinds of international perspectives. Like, don't other people care about us? Aren't there languages that will help us better seek the lives we aspire to? So this is just a call to say, or just to flag that the UNDRIP was mentioned in this case repeatedly, and it was ignored repeatedly by the state. And that led to great heartbreak. A more positive story, a repatriation case. This is, the middle person is Hale Aloha Ayau, or you may know him as Eddie. He's an alum of the CU Law School, and he also clerked at NARF, so he's a local boy in that regard. He's long been a leader in repatriation movements, as Hawaiians in general have been. And with regard to the UNDRIP, what's significant here is for 20 years, Ayau and his team petitioned the Ethnographic Museum in Dresden, Germany for repatriation of 6 po'o, or skulls. And the Germans responded, no, there's no German law that provides for this. And so they came back with NAGPRA, and they said, well, that's a US law, try again. Things weren't going anywhere. Then Hale Aloha Ayau and others in his group said, you know what? And I think they were inspired directly by Mr. Echohawk in this respect. They said, this is a human rights issue. We're here speaking as our ancestors, not just for them, but as them. And this is our human rights issue we're bringing to you. And after 20 years, that was the language that triggered the return. So they went to Germany, and I went with them in fall of 2017, and came back with those skulls, and they're now back in the ground and protected. It's a modest victory, but that Dresden Museum committed that victory would set precedent for other indigenous peoples, and now German museums writ large are taking notice, and I think there's as Hawaiians would say, a huliau, or a shift taking place, not because it was the UNDRIP was a mechanism that a lever that could be pulled in a strictly legal sense, but that it framed a language of human rights that caused people to say, oh wow, okay, that we understand that we have an obligation to pay attention to that language. So, and there they are. There's Hale Aloha Ayau, looking at the paperwork that set the precedent, and that was a magnificent moment. And I think he and his group are eager to continue appealing to the UNDRIP in this kind of a way. Let's hope that our own domestic mechanisms become more robust in the ways we're talking about today, but at least we can point to some modest steps along the way as Hawaiians and others look outward to put this to work. So, thank you. Thanks.
4 minutes, and thank you, Steve and Greg, to suggest a couple of examples where we can use specific to further inform this discussion. And so, as we've heard, there are opportunities to interpret, reform, and apply U.S. law consistent with the Articles of the Declaration, international human rights law more broadly, as Daley has said. So let's consider a few examples. So if the First Amendment has been interpreted by the U.S. Constitution not to provide any affirmative right to protect sacred sites, how might we recast or reconsider that jurisprudence in light of the Declaration? Well, you can open your little book and look at, for example, Article 11 and Article 25. So bear with me. Where we lack any affirmative right under the U.S. Constitution, but we still have this very strong principle in favor of free exercise, we might think, what does free exercise really mean? Well, Article 11 says Indigenous peoples have the right to practice and revitalize their cultural traditions. This includes the right to maintain, et cetera, their archaeological and historical sites, right? There's an affirmative right right there. It's stated perhaps even more evocatively in and helpfully in Article 25. Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationships with their traditionally owned or otherwise occupied and used lands. As a property person, I find that article very powerful because it's not limited, as Steve says, to the reservation boundaries, right? Those should include sites that are beyond the reservation. So when you're making an argument, and again, as Matthew has said, and as Jim has acknowledged, and I'm sure Steve would say too, you don't want to make this in every brief, right? And John said earlier, we have to develop a very careful litigation strategy. But there are, and Kim Gottschalk pointed this out to me, there are actually starting to be federal courts that are recognizing the Declaration on Land Rights. And in the Pueblo of Jemez case, I think it was the District Court for New Mexico recognized that perhaps the Declaration has an interpretive role when it comes to the status of Aboriginal lands. So this is in the spirit of what Jim said about using the Declaration as an interpretive tool vis-a-vis the Constitution, the First Amendment, or perhaps RFRA, the statute that further amplifies the First Amendment in this context. Steve mentioned, and we've all mentioned, the consultation process. So there are a number of federal statutes that provide and have been interpreted to provide only a procedural opportunity, a procedural right for tribes to be consulted vis-a-vis actions that would adversely affect sacred sites. Now, we have all, and everybody in this room who has worked with tribes in the US, have been frustrated with the consultation process because we spend all of this time and money, we go through consultation, and then the agency makes a decision. Not always, as Steve pointed out, there was a high point of good cooperative decision making, but under the legal standards, the agencies can still decide to disregard what they learned in consultation and go ahead with a project that destroys the sacred site anyway. If we were to take, for example, the National Historic Preservation Act, there's an analog in Canada, and to say, okay, if we reinterpreted that consultation requirement vis-a-vis emerging standards in international law, we would look at Article 19, and we would look at the right of free, prior, and informed consent. So mere consultation, mere procedural lip service is not enough under international human rights law. What it says is that states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent. That connotes mutual affirmative agreement. Ideally, we should work toward that standard in relationships between tribes and agencies on sacred sites. And there are some examples, as Steve mentioned, at Devil's Tower, at Medicine Wheel National Monument. Those are great models where the agency and the tribe come to an agreement. They put it on paper. There is actually free, prior, and informed consent. Now, could we amend the National Historic Preservation Act to actually require that? You know, that would be my dream. In the meantime, can we tell agencies that that's the best practice and it conforms with international human rights law? I would like to. And a shout out to my MRIP colleagues. We have a brand new, beautiful, wonderful study on free, prior, and informed consent that we encourage all of you to read. My last slide here about applying the Declaration specifically. The Declaration, I think, very powerfully talks about remedies in the case of lands that have been taken. Now, under US law, if we have a remedy at all, it's for just compensation, and of course a lower standard for Indians because they don't even get just compensation, they get fair market value or nothing. The Declaration says, well, that's not good enough because the significance of the land is unique, and the priority is for actual restitution of the land first. And so when it comes to lands, sacred lands that have been taken, we could look at those articles. Article 11 in particular, I already mentioned, but its second portion talks about redress, including restitution of culturally significant lands, and Article 28 that have been taken without FPIC. And similarly, Article 28 talks about actual restitution. So when you get to the point, either through litigation or through legislation or through the administrative process of talking about a remedy, why don't we talk about the remedy being actual restitution of the land? Jim has talked, sometimes this is impossible, right, because there's occupation, development, and so on. But there are some examples where the federal government remains the landowner. The Black Hills is one where cooperative solutions, some kind of actual return of the Black Hills is absolutely merited and could make a tremendous difference in this area. Bears Ears National Monument, our colleague Charles and the Native American Rights Fund, I should say, together are leading champions on this. This potentially is in the spirit of actual restitution of lands that are sacred lands to Indigenous peoples through a cooperative management structure. We're going to stop there. I'm going to give us 4 minutes for questions. Thank you all, Wado and Cherokee, and I will moderate. So if there are either comments, I should give the panel one minute for comments, or just open it up to the audience. They're declining. Questions? Yes, Phil, and then Carla will be the two questions. Mr. Twigo, I'm going to give you the mic.
My name is Phil Twigo. I'm a Sichago Lakota. I'm with the Treaty Council. Something that we thought about doing was to interpret or translate the Fort Laramie Treaty into Lakota and look at how our forefathers understood it. Would that be a good thing to do?
Yes, that's a brilliant idea, and it's in the spirit of the International Year of Indigenous Languages. It's also in the spirit of the federal Indian law canon that calls for treaties to be understood the way that Indians would have understood them. I think Greg Bigler, when he speaks, will talk about efforts at the Muskogee Creek Nation to use the language to interpret human rights, and Alexei Sikarev will mention on the panel about Indigenous languages. But yes, I mean, that's a beautiful, brilliant idea with so much potential in the courts and otherwise. Carla? I'll let others respond to this one.
Okay, I'm just going to read something and then I have a comment. Resolved that it is the sense of the House of Representatives that it is the duty of the federal government to create a Green New Deal. And I'm going to scroll down here for a minute. Some of you might know about this already. Where obtaining the free, prior, and informed consent of Indigenous peoples for all decisions that affect Indigenous peoples in their traditional territories, honoring all treaties and agreements with Indigenous peoples, and protecting and enforcing the sovereignty and land rights of Indigenous peoples, etc. So I see this whole thing that's going on here as a movement, and I think that this conference is really tremendously important as part of that movement. And one thing I'm also seeing out there in the world is that, and particularly in the United States, is that there's a serious need to build coalition as part of the movement. Daley mentioned this in her remarks about working within other mechanisms within the UN. Delegate Brown mentioned it as part of the work that they're doing with the Navajo Nation in Arizona, and it's been mentioned here too. So I would ask all of you to respond. How is building coalition with other groups, with civil society, going to influence legal change and policy?
Thank you for the great question. And Carla Fredericks is a professor here at the law school, as well as the director of the First Peoples Investment Program. Close. In any event, thank you for the great question. Responses?
Yes, I think it's absolutely important, and this Green New Deal proposed legislation they refer to as an example of that. I mean, that would be an example where you see a legislative reform incorporating the standards of the Declaration. I don't know if the I just don't know if the proposed legislation specifically references the Declaration, but it doesn't have to, right? What's important is that the standards, the international standard, is being incorporated and operationalized domestically, and that's what this proposed legislation would do. So that's a great example, and that is being done not just by Indigenous peoples, that initiative, it's by a larger coalition of interests that are proposing that. And the Declaration itself came about that way by work with alliances throughout the international community. And I think a lot of the legislative and other victories that Native peoples have achieved in this country have been done that way. So I would say, I think I'm just you just teed it up, and we got to knock it back to you that, yeah, we got to do that.
And one thing, and we're going to take 2 more minutes so that the others can chime in, but one thing so that absolutely coalitions are so important. And yet Indigenous peoples are often very vulnerable in those, right? Because as Steve pointed out, it was a coalition of religious groups that post-Smith got RFRA passed, and you all were there. I wasn't quite old enough yet. And then they left Indigenous peoples out of the coalition when it came to enforcement. And we all know the sort of fraught history between Indigenous peoples and the environmental movement. So I hope that Alexandria Ocasio-Cortez and others are more meaningfully respecting self-determination in that statement. But I don't know if others would want to chime in.
Well, I think you could look at the world through rose-colored glasses and think we're all in this together, but there are people whose motives we cannot trust. And when I say we, I mean I'm not indigenous to the Western Hemisphere. I am indigenous back, somewhere in Europe. But we who advocate for indigenous rights and indigenous peoples have to be ever vigilant that there are a lot of motives out there who would use us for their own purposes.
Greg, did you want to?
Yeah,
say
just
anything?
one thought. I learned about the Standing Rock protests because Hawaiians were there and had been there for quite a while, as had many other indigenous peoples, of course. So I guess I'd point back to the grassroots people and say they're almost always out in front of the conversations we're having, and to learn from the strength of their solidarities and communications. And so I've been humbled to learn those lessons over and over.
That's an excellent point, and I think some people were mentioning, and you were the protocols, right, that Indigenous people have for relating to one another, and those could give us a lot of guidance when it comes to setting up, dealing with allies, I guess, in a good way. And I did want to mention that I think the theme of sustainability, I know Angela Riley in the panel this afternoon is going to talk more about that, and perhaps Indigenous peoples as being out in front vis-a-vis some of those values as they're informing broader policy. With that, I just want to reflect a little bit on very quickly. So implementing the declaration, right, could happen, the declaration as a whole, or it could happen piecemeal in terms of topics or institutions or styles of advocacy. And I think we've been toggling back and forth between them. Canada, for example, has drafted a bill to adopt basically the declaration as a whole. We're talking here in the specific context of religious freedom. We hope that when it comes to the workshops tomorrow, others will have similar conversations, although specific to different topics like child welfare, business and human rights, and other issues. And the cast of those conversations may be very different, but we wanted to offer sort of one idea about how you might take the theory to practice, and also to kind of highlight the way academics and lawyers and others can work together to address some of these issues. With that, I would welcome you to come back in 10 minutes for the Cohen Lecture. Our keynote, Robert A. Williams Jr. will deliver that talk for the conference and for the faculty more broadly, and thank you to my panel.